the Legal Corner podcast series. Welcome to today's episode of The Legal Corner, a podcast which covers a variety of legal issues to keep you informed. Hosted by attorney at law Colin Denoon and communications specialist Leonardo Torres. It's a pleasure to be with you again for another episode of the Legal Corner podcast series. Unfortunately, Colin wouldn't be with us today. As a matter of fact, I would be hosting this episode as well as the next episode. And most likely, Colin and I would be joining you guys again for the following episode, which is, it does promise to be an exciting episode. So today we are going to be discussing judicial independence and the rule of law. And we have with us today as our guest, Mr. Rushaine Cunningham, who's an attorney at law. And before we bring him on, I just want to give you a brief insight on who he is. Mr. Rushaine Cunningham is an attorney at law and the founder and managing partner of Cunningham Caribbean, operating out of Antigua and Barbuda. A native of Jamaica, he maintains a regional law practice and is admitted to practice law in the Commonwealth Caribbean jurisdiction of Antigua and Bermuda, Grenada, Jamaica, St. Kitts and Nevis, St. Lucia, and the British Overseas Territory of Montserrat. Rushaine practice has involved complex multi-jurisdictional litigation in the areas of shareholders, disputes, breach of contracts, and asset tracing and recovery. Rushaine is an analytical, experienced, and dedicated advocate for his clients and is recognized as a leader by his peers and the community. He has appeared before all levels of court on a variety of matters with an emphasis on banking and finance, corporate and commercial, law and employment, as well as administrative law. Rushaine, welcome to the Legal Corner podcast series. It's a pleasure to have you. How are you doing today?
Thank you, Leonardo. It's a pleasure to be invited on the podcast. I have listened to the podcast in previous episodes, and it has really been enriching, and your guests have all been quite well. So I just hope that I'm able to live up to that standard.
Oh, thank you very much for your kind words. And well, let's just see how today's episode goes. I'm sure we're going to have a wonderful episode today.
We'll see about that.
So as mentioned previously, we're going to be talking today about judicial independence and the rule of law. So let's get right into the episode. Can you tell us what is the rule of law?
So the concept of the rule of law, simply put in layman's terms, is the idea that no one is above the law, not even the government or state powers. If we were to drill down more into the concept, then what we would find is the understanding that individuals who are in public office or exercising powers of a public office are subject to the laws of the land, and those very public powers which they exercise, whether they're being exercised by individuals or, say, state agencies, are subject to the constitution of the land. The concept also lends itself to being married to another concept known as constitutional supremacy. And constitutional supremacy is common throughout the Commonwealth Caribbean as being a part of our constitutions. And it simply means that the Constitution is the supreme law of the land. And any other law that is passed by Parliament that is deemed to be inconsistent with the Constitution, then the Constitution must prevail, and the other law is going to be treated, to the extent where it is inconsistent, as being void. The rule of law also brings into consideration certain fundamental principles, such as access to justice. And the idea of access to justice is a twofold concept because, on one hand, access to justice looks at the accessibility of the public to the laws of the land. Are the written laws of the land easily accessible by the public? Do you know where to go to find them? And then on the other hand, access to justice looks at the right of accessing the courts and having matters dealt with in a fair and expeditious manner. It also looks at the very fundamental and critical concept of fairness. Fairness in court proceedings, as well as it extends to the protection of fundamental rights which are covered under the Constitution. I think that in a nutshell properly explains what this concept of rule of law is all about.
Understood. Thank you very much for that explanation. So I'm going to ask you for another definition. Can you tell us what is judicial independence?
Judicial independence is a concept that emphasizes the principle that judges should be free from bias in their administration of justice. It is an understanding that judges should not be influenced by third parties in how they undertake their decision making powers or exercise their decision making powers. And it also extends itself to the understanding that judicial officers must uphold the rule of law as part of their functions. In doing so, judges are really expected, when making decisions, to make those decisions without fear and without favor, and certainly without compromise, having regard to what the law provides for. The concept of judicial independence is also connected to the principle of separation of powers. And what separation of powers means is simply that government is made up of three arms: the executive, the legislative, and the judiciary. And those three arms of government are all separate and independent from each other, though they work together for the proper functioning of government. Now, the truth is that in practice, the lines tend to be blurred between the executive, which is cabinet, and the legislative arm, which is parliament. But when it comes on to the independence and recognizing the independence of the judiciary, that recognition remains a very sacred one. And it is a recognition that continues to be upheld, certainly throughout the Caribbean.
Noted. And I'm glad that you mentioned that independence for the sake of fairness in terms of rulings and court proceedings. Can you talk to us now about some of these safeguards that are in place to ensure the independence of judges?
The safeguards that are generally in place for judicial independence are to be found in our constitutions, because the constitutions throughout the region offer certain safeguards. Usually, the Constitution recognizes a Judicial and Legal Services Commission, which is charged with the responsibility of seeing to such matters as appointment, remuneration, and discipline of judges. Though in from island to island, the exact procedure may vary in terms of appointment of judges, but the objectives of fairness, independence, protection from undue political influence, and other governing principles, the recognition of those principles remain the same throughout the Caribbean. In terms of, for example, say the remuneration of judges, one of the influencing factors behind the determination of a remuneration package for a judge is the consideration that judges should be so well paid. that they are unlikely to be incentivized by a bribe or unlikely to fall prey to some form of corruption. So that is a safeguard that is worked into the constitutional framework to ensure the independence of judges, even though, to be honest, a question arises as to whether or not our judges are even competitively paid. And I think that's arguably a discussion for a different podcast. But whilst that may be a question that still lingers, what we have generally done in the Caribbean is the framework we use to combat corruption or any likely acceptance of bribe by our judges is one, we rely on our judges to uphold their oaths under the Constitution. And I do hasten to add that generally our Caribbean judges are exemplary in their administration of justice and recognition of their judicial independence. But in addition to relying on judges to adhere to the standards of integrity, what we have been moving towards across the region is the implementation of codes of judicial conduct. And certainly, I can confirm that for the Eastern Caribbean Supreme Court, the ECSC in 2021 introduced a code of judicial conduct, which summarized and highlighted the standards that should be upheld by judges. And so, again, the entire constitutional framework and the legal framework from appointment, remuneration, and discipline of the judges, all those things work together to ensure that there are sufficient safeguards in place to ensure the independence of our judges.
Well noted. Now, we would have touched on judicial independence as well as the rule of law. Now, I want to get an understanding now of how does the lack of judicial independence affect the rule of law?
Because the rule of law is such a sacred concept in our jurisdictions, the lack of judicial independence would mean that judges could potentially become puppets for the executive and legislative arms of government. The impact of a lack of judicial independence is that the legal system would essentially disintegrate and there would be utter anarchy. And it may sound very dramatic, but that would be the reality. It would be a state of constitutional Armageddon because without the judges having judicial independence in how they administer justice and administer law, then our entire system of government or entire system of legal existence would fall away. And I think for your listeners, what I would want to do is just highlight, for example, in the Code of Judicial Conduct for the Eastern Caribbean Supreme Court, I just want to highlight a few of the best standards which have been highlighted in the code relative to the independence of judges in the discharge of their duties. So, amongst these best standards, judges are required to be seen as independent, as well as to be independent, and to ensure that in the exercise and discharge of their duties, they are independent of all sources of power or influence, which includes the government, the media, commercial interests, private sector interests. The code goes on to require that our judicial officers must also take care in their conduct, whether in their official professional lives or in their private lives, so as not to undermine the public appearance of independence. They are also required, and I would have mentioned this earlier, that in their administering of the law, they do so without fear or favor and without regard to whether or not their decision is popular. They are required to remain conscious at all times to whether or not there might be subtle or sometimes not so subtle influences around them in terms of how they should rule on a particular matter. Now, if you are to really think about all of these best standards and you consider these best standards being non existent, you consider a lack of judicial independence, then one can readily appreciate how, in the absence of judicial independence, the state of law as we know it, the state of governance as we know it, would certainly fall into anarchy. Because what it means is that our judges may be open to accepting bribes. What it means is that in a litigation, the litigant with the deeper pocket may be able to influence the outcome. And so justice is really then not served in a situation like that. If it is that the media or even third parties could influence the outcome of a decision, then we would lack confidence in the judiciary. We would lack confidence in the system of law. And I can't imagine what life would be like if that were to happen.
Same here. I really would not like to imagine what life would be like with that because it sounds quite chaotic, you know? At this point, we'll be taking a quick commercial break. We'll be right back. Stay with us. Okay, welcome back, and thank you for staying with us here at the Legal Corner podcast series. So, today we're talking about, as mentioned previously, judicial independence and the rule of law. And right before the break, we would have jumped into some of the definitions as well as speak on the safeguards of independence of judges as well as how they impact each other. Now, in this half of today's episode, we're going to be looking at some other aspects of judicial independence. And what I want to ask Rushaine at this point is a bit of a psychological question because it pops up from time to time in many different spheres and many different industries being here in the Caribbean. And so, Rushaine, I want to ask you, do you think a human being can truly be free from bias?
I agree with you that this borders on psychology and a bit of sociology, but I will do my best to answer. I believe that the experts in psychology would agree that human beings are not infallible. We are prone to making mistakes, but also we are never truly void of biases because we do have innate biases that are formed from our personal experiences, personal preferences, etc. But when you look at the position of a judge and the exercise of the decision making process of a judge, one of the things that is critical for us as lawyers is that we are trained in school to generally be alert to our innate biases and to readily appreciate that in any decision making process, we must follow the objective standards that are established by the law. So the simple answer is no. I don't think a human being can truly be free from bias, but it has to be appreciated that in the context of law and the role of judges, though judges may have certain biases and certain preferences, one, they are required to maintain an appearance of being independent, an appearance of being unbiased. Yes? In addition to maintaining the appearance, they are required that in their deliberation, that what they do is to apply the standards of law to the facts that are before them. And so, even though a judge may feel a particular way personally about a situation, that judge cannot impose that personal feeling or bias in the decision making process. And I think one of the questions that flows from that is, so how are you going to know whether or not a judge has imposed some sort of personal preference or bias in the decision making process? And the answer to that is simple. It is simple because, again, the decision making process is a prescribed process under law, and the law has already established the objective standards that must be used, the tests which must be used and applied to the facts. So that if a decision is handed down and the decision does not align with the facts, the decision does not align with the evidence, the decision does not align with the objective standards of the law, then it would become quite evident that there might have been some form of bias. And even if it is that you can't prove a bias, for the fact that there may have been an error in applying the facts to the law, or the law to the facts rather, there is now an avenue of appeal. Yes? And so we start from the premise that judges are expected to act judiciously, they are expected to act objectively in their decision making process, and they are expected to apply the law and the objective standards of the law to the facts presented before them. The safeguard, so to speak, of a failure to do that is an avenue for appealing a judge's decision.
I love that you made mention of appealing a judge's decision because, that goes right into my next question. Now, in the event that someone feels as though a judicial officer is biased against them, what are the remedies available for someone to get that situation resolved?
Usually, if it is that a litigant is of the view that a judge is biased, an application can usually be made for the judge to recuse him or herself. And all that simply means is the judge would remove him or herself from hearing the matter, and a new judge would be reassigned to dealing with the matter. Um, as I said earlier, under the concept of the rule of law, fairness in court proceedings is a critical component of the process. And so the threshold is not usually very high in treating with an application for a judge to recuse him or herself. Yes. Once it is that the instances of bias or the alleged facts supporting the bias are stated to the court, and once it appears that there is even a possibility of bias, even if the bias may not be a reality, but if there's a possibility of the bias, then fairness would dictate that the judge ought to remove him or herself from hearing the case. Now, I hasten to add that not because the threshold in determining whether or not to accept such an application is not a high one, it doesn't mean that a litigant should attempt to remove a judge simply because they have some sort of fanciful idea that the judge may be biased. It does require a certain degree of evidence, albeit that the evidence need not be very high. Because at the end of the day, fairness and procedural fairness and the whole idea of natural justice, that persons coming before the court must have an opportunity to have their cases treated fairly and heard fairly. Those are such critical and fundamental principles that uh, it would not be a difficult task to have a judge remove him or herself. But at the same time, if a litigant were to come to court and they simply just don't like the judge, they don't like how the judge smiled today, they don't like how the judge reprimanded them for how they dress in coming to court, those things alone would not be sufficient for an application to be successful, to say the judge should remove him or herself from hearing the matter. The other thing, too, is if you believe you had good grounds for the judge to remove him or herself and the judge refused to accept the application, there's always a route that can be taken to appeal that judge's decision and to go to a higher court and have the higher court determine, based on the principles of law governing this area, whether or not there was bias or there was possible bias, and the judge failed to have recognized those things and ought properly to have just removed themselves from hearing the matter.
Okay, thank you very much for that explanation. Now, as we begin to pull down the curtain on today's episode, I just wanted to touch on one other aspect, but this one is pertaining to the rule of law. Can you tell us if it is possible to have the rule of law in countries that have a non-democratic form of government?
In my opinion, I would say yes. And others may not agree with me, but I will explain why I say yes. The concept of the rule of law in any jurisdiction is directly related to the constitutional framework or the legal system which exists in that country. So the rule of law, as we have discussed, essentially has to do with curtailing or limiting or restricting the exercise of state powers and ensuring that the exercise of those powers conform with the constitution or constitutional principles of that country. Now, in a non-democratic society, the rights and obligations of citizens in such a society looks very different from rights and obligations of citizens in a free and democratic society. And so in a non-democratic society, power and lawmaking is centralized, and there is little to no opportunity for public influence, and certainly no legal requirement that there should be any sort of public consensus in the creation of laws, etc. So the rule of law in such a society operates based on the legal framework that exists. And so the testing of whether a particular exercise of public power is legitimate must be interpreted within the limits, or rather the unbridled restrictions that are legally imposed on the rights of its citizens. So arguably then, I believe this is why in societies like ours, where we're democratic societies, when we speak about the rule of law, we tend to use these words, rule of law in a free and democratic society. And I think subliminal within the arrangement of those words is the understanding or the appreciation that the rule of law can exist in a non-democratic society. But it's just that the operation of rule of law in a non-democratic society would look very different, because the rule of law is going to be determined by the constitutional framework and the legal system which exists in that particular country. I think it's also important to just highlight that though there is an appreciation that the rule of law can exist in a non-democratic society, this rule of law also looks very different from what international human rights organizations would endorse as rule of law or the acceptable international best standards of the principles which underpin the concept of rule of law. And so, again, to go back to my simple answer, yes, rule of law can exist in a non democratic society, but the understanding is that that rule of law is going to look very different from the rule of law in a democratic society. I wanted also, Leonardo, very quickly to highlight one other aspect of judicial independence and the rule of law that we have not touched on.
Sure.
And this has to do with the judges being in a position to advocate for themselves. Because when you look at the idea of judicial independence, and when you look at certainly the codes of judicial conduct where judges must ensure that they maintain a public appearance of independence. They have to be careful how they communicate with litigants, how they communicate with politicians, how they communicate with officials, and even the media. What it means is our judges are essentially limited or restricted in how they can advocate for themselves, certainly publicly. And so this is where the law associations in the respective territories also comes into play in ensuring that they assist with the recognition of judicial independence. Because law associations now have a responsibility to advocate for judges where it is that the judges cannot publicly advocate for themselves. And when judges are unable to publicly advocate for themselves, it usually has to do with such issues as remuneration, pensions, working conditions. And the truth is, if our judges do not enjoy satisfactory working conditions, are not properly remunerated, do not have the security of a proper pension plan, then all these things could potentially undermine their independence, because it goes back to what we have been discussing, that these things may create an opening for judges to be tempted to accept bribes, to fall prey to corruption, and more or less to fail in their constitutional role of upholding the Constitution. Yes? And so it then becomes critical that where the judges cannot advocate for themselves because they are recognizing the independence that they must discharge, it also falls on the law associations to support the judges in ensuring that they are able to maintain their independence, not only by way of not publicly speaking out about their conditions, but also that they're able to maintain the independence by the law associations advocating on their behalf to ensure that a situation of anarchy does not befall the judges or the legal system.
Thank you very much for that explanation. Now, Rushaine, I really want to thank you for your time and, of course, your wealth of knowledge. And I also have some good news for you that you have met the standard of that quality that we abide by here at the Legal Corner podcast series. So congratulations and thank you again for today's episode.
Thank you for having me, Leonardo. It was really a pleasure. And I'm quite happy and pleased, relieved even to hear that.
So again, we wish you all the best in your future endeavors. And hopefully, when topics of a similar nature that is very important to our day-to-day living as people in society, that we would bring you back again, hopefully, for another follow-up and get another good episode inside. Thanks again.
It would be my pleasure. Thank you.
Thank you for listening to the Legal Corner podcast series. For more information, please visit us at our Facebook or Instagram pages or send your comments to thelegalcornerpodcast@gmail.com. We look forward to hearing from you.